Get up to 2 months of free podcasting service with Libsyn. Check out the show notes for your promo code to get started podcasting today.
Speaking of trust, there's two main types of trust. And again, another level of complexity or confusion for a lot of people. Some people think, okay, well, I've got to trust. So if someone sues me, I'm protected. Well, that's not true of a revocable living trust. So a revocable living trust is the main vehicle that we utilize on the estate planning side that allows us to get the benefits that I just mentioned. Avoid probate, we can avoid taxes, handle everything privately and immediately. But it's revocable, meaning that you can change it at any time. So you have that flexibility, that freedom, so that as things change, as your life changes, as the law changes, as your assets change, you can make updates to your revocable trust. But there's no asset protection during your lifetime.
Welcome to the Unlocking the Club podcast, where we host honest and direct conversations about journeys of access, personal truth, and reclaiming space. We share our truth so that you can find the key to own your truth, honor your journey, and reclaim your space. Grab your keys, your wallet, your phone, and invite your friends to meet you at the club. Here's your host, Angela Taylor.
Hello, everyone, and welcome to a very special series of Unlocking the Club, where we explore one of the most important yet often overlooked conversations that we can have: estate planning and elder care. I'm your host, Angela Taylor, and I want you to know that my inspiration for this series was the fact that over the past few years, my family, friends, and I have all learned the hard way about the critical importance of having a will or trust in place. When unexpected moments arise, not having a plan can leave families vulnerable, and I've seen firsthand how it can create chaos during already challenging times. Recently, I conducted a poll, and the results were eye-opening. 80% of people between the ages of 20 and 65 do not have a will or a trust in place. Even more striking is that most of those who do, in fact, have a plan in place actually only took action after experiencing a tragic event. National data supports this as well, with studies showing that a significant majority of adults, particularly within Black and BIPOC communities, have not taken steps to secure their legacies. And when we fail to plan, we leave our families with legal battles, financial burdens, and emotional stress that can take years to untangle. That's why we're dedicating an entire 12-part series to unlocking the essentials of estate planning. Together with two brilliant legal minds, Shane Jasmine Young from Young Law Group and Berlina Green-Toluska from VDG Law Group, we'll break down what you need to know about protecting your assets, building a legacy, and making sure your loved ones are cared for when it matters most. Our goal in this series is to equip you with the knowledge and the tools to take action now before life forces you to. Whether you're just starting out or you're navigating the complexities of caring for aging loved ones, these conversations will give you the clarity and the confidence to plan for the future. So grab your notebooks, tune in, and let's unlock this critical conversation together. Welcome to Unlocking the Club's special series on estate planning and elder care. Estate planning isn't just for the wealthy. It's a vital step for anyone who wants to ensure that their assets are handled according to their wishes and their loved ones are protected. Today, we'll break down the basics of estate planning and explain why it's important no matter your age, no matter your assets, and no matter your family situation. Joining us today to discuss long-term care planning, elder care, and the basics of estate planning is Shane Jasmine Young of Young Law Group. Shane, thank you so much for joining us.
Thank you so much for having me.
Well, I know that we recently had a conversation just getting to know you and your journey, and it was quite fascinating for me to just understand what the genesis of your passion for this particular craft was. And just for you from a personal perspective, before we put on the legal esquire hat, what's the importance of estate planning?
The reason why I love the work that I do is because estate planning touches everyone, right? And, everyone's lives can be impacted by planning or the lack of planning or failure to plan. So for me, it was more so being able to do work where I'm making a difference. It's meaningful, it's impactful, and I have the ability to do things like this. So thank you for the work that you're doing and the information that you're sharing, because it's so important. Because when we don't know what we don't know, that's where all of the mistakes happen. That's where all of the tragedy occurs. That's where all of the probate, the court, the taxes, all these things that are unnecessary, become reality because we didn't know any better. And, you touched on it earlier. It's, particularly, in our community, it's this failure to have the resources or to take action for whatever reason. And so that's why it's so important that we're talking about this today and we continue these conversations. And really, thank you for the opportunity to have such an extensive series, because it's hard to pack all of that information, into one episode. So it's going to have such a lasting impact and be such a great resource for everyone, really.
Well, I appreciate you acknowledging that. I thought about like maybe I'll just bring one guest on and we can talk about it. Was as I started to learn more about estate planning, there's just no way that you can pack all of this information into one conversation, and that's why it's so important for all of you that are out there listening or watching us on YouTube to take your time and to watch each of these videos or listen to each of these episodes with your family and your friends. It's so important that we take the time to really consume all of this information. And I have to admit, Shane, I'm a child of the 70s and 80s. So I grew up in the summertime with my mother watching soap operas.
Yeah.
And when I hear the word estate planning, I think about Victor Kiriakis or all of these wealthy folks that are in our communities with a house on a hill or who have art in their house, a real estate and assets to be able to protect. Like, what is estate planning, and like what are some of the things that we should consider regardless of our wealth, our financial situation, or our age?
Right. So great question. And you brought up one of the most common misconceptions, right? That you have to be wealthy to have an estate plan. And that's not true. If you're over 18, which, if you're a legal adult, you need to have some type of planning in place. A typical 18-year-old's plan is going to look a lot different than someone, who's in their 40s, that may or may not have children or a business or, these different family dynamics or, financial dynamics. But if you're 18, you need to have, at least some foundational planning, because mom and dad can't legally make decisions for you anymore. And so going to your question of, what is estate planning or what is an estate plan? An estate plan really should be a comprehensive plan that addresses all types of contingencies from, if you're in an accident, if you become disabled, if you are hospitalized, who can step in immediately to talk to your doctors, get access to your medical records, make your medical and end of life decisions without having to petition a court or go in front of a judge, who can go and handle your financial affairs, go to the bank for you, pay your bills, pay your rent, pay your mortgage, who will take care of your children if you've got children that are minors under 18. Of course, what happens to your assets when you're no longer here, the wealth that you have accumulated, whether it's a bank account or investment accounts, retirement accounts, vehicles, your personal property, your digital assets, all of those are assets that we want to make sure are properly planned for, and all of those other contingencies.
I'm so glad that you said, like, right, you become an adult at 18, and, having an estate plan is one of those adult decisions. When you're thinking about it, again, it feels very intimidating. But when you break it down, what are some of the fundamental documents or elements that are included in a typical estate plan?
Right. So most people have heard of things like a will or a trust or powers of attorney. All of those can be components of an estate plan, but really you need, a comprehensive plan. So I'll kind of break down, these main components. So, typically people have heard of a will, right? So a will really deals with the disposition of your estate, of your assets when you're no longer here. It basically says who gets what. Now, common mistake that people make is people think, okay, well, I've got a will, so I've got my estate planning taken care of. Well, they don't realize that a will actually does not avoid probate and would have to be filed in the probate courts and become it becomes a public record. So you might have heard of certain celebrities that have died with wills, like Jackie Kennedy Onassis, Aretha Franklin. Her estate is still going through the probate process, and she died several years ago now. So if you only have a will or you have no estate plan, that's all public. It all becomes part of the public record, and anyone can get access to that information. So it's really a pretty dangerous type of situation when you think about it, because your family's information is disclosed, personal information like home addresses, contact information. Your asset information is part of that public record, because creditors are the first ones that get to make claims against your estate. So those assets get tied up until the creditors and the court process is finalized. And then whatever's left goes to your heirs at law, or the heirs that you've designated in your will. Sometimes it's not the people that you would actually want receiving your assets, and it might not be the best situation for potentially young beneficiaries who aren't financially mature. So those are some of the dangers of going through the process, the probate process, and or only having a will. So a will in and of itself is really a very basic document. It just says who gets what, and it does not avoid probate. Now, a trust, on the other hand, is a much more comprehensive set of documents, and it allows us to bypass the court process known as probate. So we don't have to go through that public court process. We can actually handle things privately and immediately by the people that you want, that you appoint as your trustee or trustees. So when we talk about a trust, there's typically three parties to a trust. The first party is the grantor or the grantors. That's the people or the person that creates the trust. So that's you. The second party is the trustee or trustees, the people that are vested with the responsibility of managing the assets within the trust for the third party or parties, which are the beneficiaries or the beneficiary, the people that can receive the assets. So while you're alive, you play all three roles, right? You're always going to be the grantor because, forever and always, you created the trust. You manage your assets during your lifetime for your own benefit while you're alive. And then, of course, after you pass away, a successor trustee, someone that you've appointed that you trust, steps in, makes sure that those assets that you have in your estate are properly distributed according to the terms of the trust to your beneficiaries that you've designated. So instead of your beneficiaries just receiving whatever's left at age 18, which is the default in an outright distribution, we can actually plan for those different contingencies. If you happen to have a young beneficiary, if you want that beneficiary or any of your beneficiaries to have asset protection so that if they get married, it doesn't become part of the community property estate or get taken away half in a divorce or in a bankruptcy or by the IRS or any other creditor, like if you're sued. So there are a lot of different things that you can incorporate into a trust versus a will, which is a very, very basic document. So the trust allows you to completely bypass the court process, avoid probate, handle everything privately and immediately according to how you would like things structured within your trust. And you can also avoid taxes. So you're able to plan for all of these different circumstances and contingencies. Now, speaking of trust, there's two main types of trust. And again, another level of complexity or confusion for a lot of people. Some people think, okay, well, I've got a trust. So if someone sues me, I'm protected. Well, that's not true of a revocable living trust. So a revocable living trust is the main vehicle that we utilize on the estate planning side that allows us to get the benefits that I just mentioned. Avoid probate, we can avoid taxes, handle everything privately and immediately. But it's revocable, meaning that you can change it at any time. So you have that flexibility, that freedom, so that as things change, as your life changes, as the law changes, as your assets change, you can make updates to your revocable trust. But there's no asset protection during your lifetime. So if you are a business owner, or if you are in an accident and someone sues you, you caused the accident, if you have any creditors, if you owe the IRS, those assets in that revocable trust are within the reach of creditors. Now, another type of trust or another category of trust is irrevocable trusts. So the main thing about the irrevocable trust is two things that they all kind of have in common. One is they're irrevocable in that technically you can't change the terms of the trust, right? So once you set it up, you're supposed to kind of be stuck with those terms. The second major component is there's some enhanced, some high level of asset protection. And there's lots of different types of irrevocable trusts. The main one that we deal with, that we offer clients in Nevada and outside of Nevada, is what's called the Nevada Asset Protection Trust. And other states, certain other states, about 17 other states offer certain types of domestic asset protection trusts, but none are as good as Nevada, actually, because we have a bunch of benefits, a flexibility in our laws that allow for you to be able to make changes, for you to protect against all creditors versus just, a select few. We have the shortest vesting period. So you get the best protections in Nevada. And the nice thing is you don't have to live in Nevada to set that up. So lots of other different types of irrevocable trusts like insurance, ILITs, Medicaid asset protection trusts. But those are kind of the two main categories of trusts. And then I also mentioned another set of documents which include powers of attorney. And that's things like healthcare, directives, medical powers of attorney, financial durable powers of attorney. And powers of attorney come into play while you're still alive, but you become incapacitated or you can't handle those decisions. So it's someone that can step in and handle your medical decisions, talk to your doctors, take care of your financial affairs and so forth. So those are documents in that category. We call them incapacity documents or ancillary documents because they're separate from your will and your trust, but they're all part of your overall plan. And then another set of documents that can also be part of your plan is what we refer to as child protection or kids protection planning. And that's for families that have young children under 18. So any family that has minor children, this is something that we include as part of your plan. It's complimentary. I've got 3 minors still, so we want to make sure that all of those bases are covered. And what that includes is short-term guardianship nominations, long-term guardianship nominations, who would raise your children if you weren't here to raise them, ID cards for the parents to keep in your wallet so that if you are in an accident or if there's a first responder type of situation, they know exactly what to do so the cops don't show up to your kid's school or show up to your home and take them out of your home into child protective services. Because that's the reality if we don't have proper planning for our children as far as guardianship documents. So those are all part of it. Medical powers of attorney also for your minor children is part of the kids protection planning that we do. And that's also to our benefit because, if we're going on vacation, mom and dad are going on vacation and the kids are left with a family member or a babysitter or a caretaker, those powers of attorney allow them to seek medical attention so that your kids are taken care of. And then also if you've got pets, we do pets protection planning, very similar to the children's protection plan.
Wow. Which it all sounds so overwhelming. Right. So if you are starting out on this journey, like the holy grail is to make sure you do all of those. What should you start with?
Yeah, a great starting point is actually what people are doing right now, watching or listening to this podcast, right? Getting the information is so important. So that's step number 1. Another resource that we offer to that end is our on-demand webinar on our website. So if you go to younglawlive.com, there's an on-demand button and you actually can watch a 60-minute video right there on our website. And you'll get a lot of this good information. You can share it with anyone that you like, rewatch it. And you can schedule actually a complimentary session. So I would say, start with getting educated, utilizing these resources, and then also scheduling a session. So I offer what's called a life and legacy planning session, and we can do the session in person. So if you're in Las Vegas, that's where we're located. That's where we're based in Nevada, but we serve clients all over the states across the nation. And we can do planning virtually. So just like how we're doing the podcast virtually, we're able to do planning the same way. And that session starts with, even before the session, we ask that you watch the webinar, get familiar with some of these concepts so we can make the most of our time together. You complete what's called a family profile. So it's some basic information about your family, your needs, your concerns, the questions that you might have, a little bit about your asset, information, and, kind of just high level stuff. And that way, when you come into the session, we're able to go through that family profile together. I'll ask some more questions. I do an analysis of what would happen, based on where things are right now. Before we do any planning together, what does that look like? So that we can get clear on, okay, would there be a probate situation? Would there be a tax situation that we need to address? Are those things that you want to avoid? What are the other concerns that you have? What are the priorities? What's the most important thing? And so we get really clear because, what's important to you may not be important to me, and everyone is different. So having the opportunity to have those one-to-one conversations and have that meeting, with an actual attorney that really cares and asks questions is so, so valuable. So any of your podcast listeners, watchers, anyone that's part of your circle, part of this audience, will get a complimentary life and legacy planning session. So normally we charge $750 for that. And when they book the session, I'll also give a $500 discount on any planning. So it's really, really, important information that you have resources available now. So there's no excuse.
No excuse at all.
No
Oh my
excuse.
goodness. That is so generous of you. And what I think is important about something you shared, Shane, was that it doesn't matter where you are. Like that, Nevada has higher protections for you. So that is even more intriguing should be for all of us. That now we have an expert in Nevada that's offering that's a great deal. And Nevada in and of itself also provides extra protections that you may not get in other states. Fantastic. Well, as you were talking, just listening to, again, this can feel overwhelming for many, particularly if you are early on in your journey and not thinking, that this might be something that is important to you. But I know over the years that you've been doing this work that you've seen the ramifications of not having something in place. And I'm wondering if you can just maybe share some of the consequences or anecdotal stories that you may have of not having an estate plan in place and what may happen in such cases.
Right. Well, I mean, I hear stories all the time, as you can imagine, right? Even today, I was speaking at another engagement and one of the attendees had raised her hand and she, she was like, yes, you're preaching to the choir because I was married and we thought that we had things taken care of. And I thought that because I was married, that everything would be taken care of. Well, my husband passed away unexpectedly. And it wasn't until after he passed away that we realized there was a mistake in our plan and a mistake on our deed. One word caused a problem to where his ex-wife, through his biological daughter, now she has to share that property with his ex-wife and daughter because of one word, one simple mistake that can have huge ramifications. So that just today, that was one example. Another example is, my first pro bono case. I think I mentioned, kind of my why in our earlier episode. And my first pro bono case, I was working with a family who had a plan in place. He had the father that passed away had a trust, but it wasn't done properly. It had never been reviewed, had never been updated. So his assets were not properly titled. This, common mistakes that people are making that we see every day. And his estate still had to go through probate. And one person, a beneficiary that he probably didn't intend to inherit, was his ex-wife. So she was still listed as a beneficiary. And that's what happens when people rush through it. They rush through the process. Even working with other attorneys, they don't necessarily take the time, and it can be very transactional. It can be like, okay, here, sign here, see you later, collect a check, and then you never hear from the attorney again. And your plan is never reviewed, it's never updated. So you really want to work with someone, and you want to work with a law firm that really has a process in place that is there step by step for you. And, you talked about being overwhelmed. It can sound like an overwhelming process. But what we do is, we really take it and break it down, into bite-sized chunks so that you don't become just overwhelmed and, that paralysis that ends up taking over for some of us. So, we start with the education, and then we go into the counseling, and then we go into the opportunity to design a plan, and walk you through options and recommendations. And then even after that, it's every step of the process is laid out. I've spent a lot of time over the years refining the process based on my experience. I've been an attorney for 20 years now. I mean, that's hard to even, for me to even put the words to that. But, through all of these years, I've learned so much. And also because I've worked with so many family members, so many friends that are close. And, I've built out a process that works for all of us, no matter what our dynamics are, no matter what our different situations are, whether we have children or if we're single or if we're married or if we have a lot of assets or a little bit of assets. Everything is customized, and we really work through the process of planning together. And we do the heavy lifting. We're there to guide you. We're there holding your hand, step by step. And something else that's unique to our practice is we have a compliance department. So before a plan leaves our office, it's reviewed again by our compliance officer so that we make sure that we're not missing a word here or, any little mistakes. All of our, I's are dotted and our T's are crossed, because it has huge consequences if we don't make sure that those things are taken care of. And like I, shared with you, we see these mistakes happen all the time. And, when it's someone else that has done the planning and then the families are coming to us and they're saying, oh my gosh, like, what do we do? My heart breaks for them, because I know, they thought that they were doing the right thing. And, unfortunately, it doesn't always work out that way.
Yeah. Well, and the decision of whether to put something in place and not to,
Mm-hmm.
thousands and thousands upon thousands of dollars.
Yes, yes. A common question that I get asked is, okay, well, should I do it now, or maybe I should wait for a few years? And my answer is always, do it now, please. And that's the beauty of having a dynamic estate plan, is we're able to make updates because we expect your life to change. You might move, you might get married, you might get a divorce, you might have a child, you might have a death in the family. You get a new car, you open a new bank account, you close an account. These are all things that go into your plan that need to be updated and need to be talked about regularly so that you have a good plan, that's updated and current moving forward.
Well, picking up on that, how often should someone revisit and update their estate plan? Is there a formality to it? Can they just add a written addendum, or what life events might trigger some of these updates?
Well, I have an example of why you want to be careful about that, but I'll answer that second part about like doing it yourself, like an addendum. So don't let me forget about that. But as far as your first question, how often should you be reviewing your plan? One of the things that we do is, for all clients, we review your plan every 3 years. So at a minimum, every 3 years, you should be reviewing your plan. The reason for that is certain documents like financial powers of attorney, for example, tend to go stale or expire. And it's not by the terms of the documents themselves. It's usually the policies of certain financial institutions where something happens, you take that power of attorney to the bank and the bank says, I'm sorry, we cannot accept it. It's too old. So, a 3-year period for updating at least those documents, doing a review and updating at least those documents is, baseline. What I really recommend is an annual review, because a lot can change over the course of a year. Your assets change, your life changes, your family changes, the laws change, pandemics happen, a lot can happen, in the course of a short time span. So that's one of the benefits of our VIP membership program, our client service program, is if you are part of that program, we do an annual review. So we will reach out to you every year and say, hi, Angela, happy anniversary. It's been a year. Has anything changed? Oh, okay, great. You closed that account. Let's update your family wealth inventory so that stays current. Oh, you got that life insurance policy? Great. Let's make that update. So those updates are complimentary for our VIP members. If you're making other updates or amendments to your plan, those are either complimentary or you get a discount of 50% off. If you've got other family members, whether they live in Nevada or in your state or any other state, we are able to do their plan planning, and we offer a discount, typically 25% off, up to $2,000 off of their plan. Every 3 years, we do new powers of attorney for VIP members. You get access to a smart vault where all of your documents are stored electronically. You have your own credentials, your own login. We pay the subscription fee. So those are just some of the benefits. But one of the main things is that annual review, going back to your original question of, how often should you be reviewing it? So I recommend every year, but at a minimum every 3 years. And then the other part of your question, I believe, was, what about like addendums and making amendments? First, I always recommend talking to your attorney. Call us if we are your law firm and let us know what you're thinking about. I tell clients all the time, do not write on your documents because you can actually void them. There are a couple of exceptions, like your personal property memorandum. So personal property, things like if you think of your home, if you dumped the contents, out, it's your jewelry, your shoes, purses, furniture, appliances, electronics, artwork, those things that aren't necessarily titled, but they belong to you. So there is a memorandum that we include where you can say, okay, I want my diamond ring to go to my daughter. I want my watch to go to my nephew. I want my baseball card collection to go to so-and-so. So you can actually write out on that personal property memorandum, and you can make updates to that. So if you want to cross things out, that's kind of the exception there. Otherwise, if you're wanting to make amendments or do an addendum, it's best to work, through someone who knows how to do that properly, because I'll share this example with you. We had a client that came in, he did his planning with us, years ago after he had lost his wife. And so he was like, I need to get my affairs in order. We put a trust in place for him, and, everything was good. Later on, he wanted to make some updates. He actually worked with a paralegal, a document preparer that wasn't affiliated with our law firm. They put these other documents in place. And then after that, he came back to his original plan with us to make an amendment. And he hand wrote, these changes on a document. And I actually, after he passed away, of course, there was a conflict between the people that were benefiting under, the second plan versus the third plan. And it was a lot of confusion. His fiance at the time was actually living in the home, and his prior beneficiaries were trying to take the home from her. So his intention was to have her be able to stay in the home, and the home to go to her because she had actually put money, she paid towards the down payment, but she just wasn't on the title. So that like third iteration, that amendment that he drafted to our plan was for her to be able to have that home. So I was actually called in as a witness to that court case where the judge essentially relied on my testimony to be able to thankfully rule in favor of the fiance and uphold his intention. But it still cost the family and her, a lot of money, attorney's fees, time, grief, all of those things. So yeah, those are just little things where it's like, okay, don't just start writing or making amendments, because there's a certain way that it needs to be done. And it's best to have the advice and counsel of, your lawyer as you do that.
No, that's such great insight. And as you're speaking, there's a couple things that are resonating. First, when you talked about, just the fact that your firm, the Young Law Group, is on an annual basis, right?
Mm-hmm.
And going ahead and making an assessment. That's why it's so incredibly important for all of you out there listening and watching us on YouTube, that you find the right firm, not just any law firm that can do this, but the right firm that really you are assessing their capability to put you in the right position. Because I know for sure, and had a family friend who passed recently, and about 26 years ago when he got out of the military, he put a will together. But since then, his wife passed away. He started dating somebody else. 2 of his children passed away. 2 of his children were named as agents.
Mm-hmm.
And now, right, everything just was upside down 6 years later, and you knew his heart was in the right place. And I think the other reason why it's so important to consider the right people to work with
Yeah.
state is, I know for my process with my father of going through it, on the front end, it was nervous having this conversation with my dad, talking about things that in my family felt like they were off limits before, right? You just don't want to talk about certain things. But by the end of it, But last time we were sitting across the table from the attorney and signing off on things and walking through all of the documentation, we were giddy. We even on the ride home, we're like, let's go for ice cream.
Right.
It felt so much better. And I'm like, I wish we had done this for my mother.
Yeah.
Just a year before. Like, it doesn't have to be this ominous.
No. And even for those people, I'm glad you bring that point up, because there are a lot of people that are so hesitant. They put up this resistance to having the conversation. And oftentimes we see it with couples, a married couple where one person is like, yes, we've got to do it. And the other person is like having to be dragged in, into the office or, to come to the session. But by the end of the session, that person that was reluctant is like, oh, you know what? I feel so much better. I feel like a weight has been lifted off of my shoulders. It just brings you this peace of mind that is unmatched when you do planning, and you're planning while you are alive and well, and you're not planning in a state of panic, because the clock is ticking because so-and-so's in the hospital. We get those calls, and, again, like, my heart breaks for those people, because it's not the situation that you want to be in. You want to have planned ahead of time so that things are taken care of. So when you are dealing with those, very difficult situations, illness, death, that you can focus your attention, and your family can focus their attention in the right direction.
Yes. Well, we're here on Unlocking the Club. I'm your host, Angela Taylor, here with Shane Jasmine Young, and we're talking about the ins and outs of estate planning and the importance of estate planning. And, Shane, before we wrap up, what would you say is maybe one of the single most important takeaways for our listeners and viewers?
I would say, the takeaway is to take action now. Don't put it off for another day. We get busy and we have good intentions, right? So you might be listening and be like, oh my gosh, I didn't realize this. Or, I need to go do that. I'm going to do it later. Don't wait for later. Don't procrastinate. That's the worst thing. Take advantage of the resources and the opportunity that you have now. I've shared with you my website, younglawlive.com. Watch that video, share it with your family members, schedule your complimentary session there. That's my gift to you as, a listener and supporter of the podcast. And then $500 off your plan when you book. So, there's no excuse. Just don't put it off, because you're going to get busy, and you're going to get distracted with life. It happens, even those of us with the best intentions. So do it now while it's on your mind, and you can make sure that you're utilizing your resources.
Wow, Shane, thank you for kicking off Unlocking the Club's estate planning series with such a bang. I appreciate what you're doing, and we will make sure that we'll share that information with our listeners and our viewers. It'll be in our show notes. We'll make sure to post it on all of our social media outlets as well. It's too good to pass up this opportunity to not just have this work done, but to work with someone who is at the top of their field and really cares about you and your family and your legacy. So Shane, thank you for that offer. We will make sure that we get it to all of our listeners. And for our listeners, whether you're just starting your estate planning journey or have been thinking about revisiting your plans, today's conversation should serve as a reminder that those decisions that you are confronted with right now are too important to put off. Today, make sure you log on to Shane's website today, sign up for that opportunity to talk to some experts, make sure your estate plan is up to date, make sure that those folks in your network and your community, that they have something in place as well, so that we can all make sure that we protect our assets and the things that many people in our families have worked long and hard to make sure that we have access to. So Shane, it was such a pleasure having you on Unlocking the Club today. Thank you for sharing your expertise around estate planning, wills, and trusts, and for making these complex topics feel maybe a little bit more approachable and doable.
It's my honor, and thank you for having me.
Awesome. All right. For the audience, if you found this episode helpful, don't forget to share it with family and friends. These conversations can spark the action that's needed to ensure that all of our futures are well taken care of. Stay tuned for our next episode, where we'll continue to break down the essentials of estate planning and elder care. And until then, take care of yourselves and take care of each other. Be well.
Thanks for listening to Unlocking the Club. If this conversation resonated with you, subscribe to our podcast on iTunes or your favorite streaming platform so that you can experience every episode. And follow us on social media, where you'll hear about future guests. access special features, and connect with this amazing community, head on over there and let us know how you are unlocking the club. Until next time, peace.